Federal prosecutors building a criminal case against Donald Trump rely heavily on witnesses who can describe what they personally observed, what they heard in real time, and what instructions they were given. These witnesses are typically individuals who worked directly alongside Trump, who were present in key rooms when decisions were made, and who possess first-hand knowledge that no paper trail can fully capture. Because this testimony is so powerful, it is also extremely fragile. Witnesses can be pressured, influenced, intimidated, or persuaded that allegiance to a former president should outweigh their obligation to tell the truth before a grand jury. When that pressure crosses certain boundaries, it becomes a serious federal offense. And on a night in late 2023, one of Trump's own attorneys crossed exactly that boundary. At 2:17 in the morning, the attorney sent a text message to a witness who was scheduled to testify before a federal grand jury. The message was short, but its meaning was unmistakable. Remember what the boss said. Think about your family, make the right choice. The recipient, a former Georgia election official who had recorded phone conversations with Trump during the aftermath of the 2020 election, acted immediately. Within minutes, the witness took a screenshot of the text and forwarded it directly to the FBI. That single image fundamentally altered the trajectory of the case. What had initially been a prosecution focused on Trump's efforts to interfere with the election became, almost instantly, a prosecution that also included charges of witness tampering against both Trump and his attorney. The evidence was not vague or circumstantial. It was time-stamped, preserved in its original form, and nearly impossible to reinterpret or dismiss. To understand why this moment matters, it is essential to understand what witness tampering is and why the law treats it with such severity. This is not merely about one alarming text message. It goes to the heart of the integrity of the entire legal system. The American criminal justice process depends on witnesses being willing to testify honestly and without fear. Without truthful testimony, trials become performances rather than truth, seeking proceedings. Juries cannot deliver just verdicts if witnesses are intimidated into silence, deception, or non-cooperation. For that reason, the law protects witnesses from interference, coercion, and intimidation with exceptional force. Title 18, Section 1512 of the United States Code makes it a federal crime to intimidate, threaten, or corruptly persuade any person with the intent to influence, delay, or prevent their testimony in an official proceeding. The statute is intentionally broad. It encompasses not only explicit threats of violence, but also indirect pressure, implied consequences, and communications designed to instill fear or doubt in a witness considering cooperation with investigators. The penalties reflect how seriously the law views this conduct. A conviction for witness tampering can carry a sentence of up to 20 years in federal prison. Unlike other federal statutes that require prosecutors to untangle complex intent or ambiguous language, Section 1512 is relatively clear. If you communicate with a witness in a manner intended to influence their testimony, and that communication involves intimidation, threats, or corrupt persuasion, you have committed a crime. The witness in this case was someone federal prosecutors had been carefully cultivating for months. This individual was a former official in the Georgia Secretary of State's office who had been present during some of the most pivotal moments of Trump's attempt to overturn Georgia's 2020 election results. The witness participated in phone calls where Trump pressured state officials, observed internal communications, and critically made contemporaneous recordings and notes. This kind of documentation is especially valuable to prosecutors because it anchors testimony in real-time evidence and makes claims of misunderstanding or faulty memory far less credible. When the witness was subpoenaed to appear before a federal grand jury, Trump's legal team would have understood the danger. This witness could corroborate other accounts, provide details no document revealed, and offer first-hand insight into Trump's mindset, intentions, and awareness of the legal and factual environment at the time. In short, this was a witness whose testimony could be deeply damaging. It appears that someone within Trump's orbit decided that this witness needed a reminder of where loyalties supposedly belonged. And so, at 2:17 a.m., the message was sent. It did not explicitly threaten violence. It did not list specific punishments, but it invoked the boss, an unmistakable reference to Trump. It told the witness to think about your family, a phrase that, in the context of a criminal investigation, carries clear and ominous implications, and it urged the witness to make the right choice, implying that there was an alternative to truthful testimony. For the attorney who sent the message, the apparent calculation was that the witness might be swayed, that fear, loyalty, or both could cause the witness to soften testimony, omit damaging facts, or suddenly develop lapses in memory. But that calculation failed. Instead of being intimidated, the witness immediately recognized the message for what it was. Within minutes, the witness captured the message in a screenshot and forwarded it to federal investigators with a brief explanation of the circumstances. That screenshot became one of the most critical pieces of evidence in the case. It was time-stamped at 2:17 a.m., establishing precisely when the contact occurred. It preserved the exact wording of the message, along with metadata that made claims of manipulation or misinterpretation implausible. And it came directly from the witness, eliminating any chain of custody concerns or questions about authenticity. The message existed, it was sent, and its meaning was unmistakable. Federal prosecutors responded swiftly. Witness tampering charges were added to the indictment. The attorney who had sent the message, previously part of Trump's defense team, became a co-defendant facing serious criminal exposure. This immediately created cascading legal problems. The attorney could no longer represent Trump due to conflicting interests. Separate counsel was required, and the attorney's knowledge of Trump's legal strategy, once protected by attorney-client privilege, became a potential bargaining chip if cooperation appeared preferable to conviction. For observers outside the courtroom, the full significance may not be obvious, but this episode illustrates how criminal enterprises often unravel. Trump's legal troubles did not arise solely from his own actions. They expanded because people around him, believing they were protecting him, committed additional crimes. The original charges focused on election interference. The witness tampering charge broadened the case to include obstruction of the investigation itself. Each new offense created new vulnerabilities. Each new defendant created opportunities for cooperation, and every act of intimidation served as evidence of consciousness of guilt. Meanwhile, the witness became even more valuable. Before the text, the witness was simply a source of relevant testimony. Afterward, the witness could testify not only about Trump's conduct during the election, but also about efforts to silence that testimony. The witness could describe receiving a threatening message in the middle of the night, explain the fear it was meant to instill, and tell the jury that despite that pressure, cooperation with law enforcement was chosen over intimidation. That kind of testimony is powerful. It humanizes the legal process. It shows jurors that real people with real risks chose to uphold the law. And it demonstrates that the defendants were not merely engaging in political hardball, but in criminal conduct designed to undermine the justice system itself. The legal framework governing witness tampering exists precisely to prevent this behavior. The law recognizes that witnesses may have personal or professional ties to defendants and may feel conflicting loyalties. What the law does not permit is resolving those conflicts through threats, pressure, or intimidation. Attorneys may contact witnesses for legitimate purposes, but such contact must be appropriate. It cannot suggest consequences for truthful testimony or attempt to corrupt a witness's willingness to tell the truth. The timing of the message 2:17 a.m. is itself revealing. Messages sent in the middle of the night carry an implied urgency and menace. They suggest desperation, panic, and an attempt to catch the recipient off guard. A witness receiving such a message is more likely to feel isolated and vulnerable. The timing was not accidental. It was part of the intimidation. Ironically, that same timing undermines the attorney's defense. A 2:17 a.m. message does not resemble legitimate legal advocacy. It looks like the act of someone frantic to stop testimony they know will be damaging. When prosecutors present that message, along with its timestamp and context, the conclusion is difficult to escape. This was obstruction, not representation. The attorney now faces a familiar federal dilemma: fight the charges or cooperate. Conviction could mean years in prison, disbarment, and the end of a legal career. Cooperation could mean leniency, and while attorney-client privilege exists, it does not protect communications made in furtherance of a crime. If prosecutors establish a conspiracy to obstruct justice, much of what the attorney knows may no longer be shielded. For Trump, the witness tampering charge creates another serious vulnerability. Even an acquittal on the underlying election interference charges would not eliminate liability for obstructing the investigation itself. History is filled with cases where the cover-up became more damaging than the original conduct. There is nothing ambiguous about a screenshot of a threatening text message. There is no plausible innocent explanation for telling a witness to think about their family and make the right choice. By contrast, the witness now stands in a position of strength, protected by prosecutors and presented to the jury as someone who resisted intimidation and chose truth. This episode also exposes a broader dysfunction in how Trump and his associates confront legal risk. Rather than respecting the rules that govern the legal system, they appear to believe that loyalty, pressure, and intimidation can override institutional constraints. That belief has repeatedly proven false. Courts do not yield to threats. Witnesses often become more resolute, and obstruction only multiplies criminal exposure. The 2:17 a.m. text message is now part of the official record. It will be introduced into evidence, analyzed in court, and shown to a jury as proof that Trump and his attorney believed the witness's testimony was dangerous enough to suppress. That fact alone is devastating, and as this case moves forward, the witness tampering charge may become one of the most compelling aspects of the prosecution, because juries may struggle with complex election law arguments, but they never struggle to understand that threatening a witness is wrong. The American legal system will ultimately be tested by this case. It will show whether the law applies equally to former presidents and their attorneys, whether intimidation can be punished even when political power is involved, and whether witnesses who choose to cooperate can be protected. The 2:17 a.m. message stands as a stark reminder of what happens when those lines are crossed.